The government has managed to subvert its own campaign in favour of the proposed constitutional amendment on children by engaging in conduct that the Supreme Court today found to be illegal. Can the government be depended upon to lose this referendum as it lost the referendum on Oireachtas inquiries? That's after the news now with Alan Cantwell.
Good evening. The children referendum will go ahead on Saturday despite today's ruling by the Supreme Court that the government information campaign is in breach of the law. The court ruled the government used money for its campaign in a manner that wasn't fair, equal or impartial.
This is the government's information website this afternoon, containing only basic information on the wording of the amendment to the Constitution. Up until today it had published detailed material, but it had to be changed after the Supreme Court ruled the state acted wrongfully in spending public money on its information campaign. Dublin engineer McCrystal took the legal action against the government.
We just had a clear and unanimous decision by the Supreme Court. The state has been unfair in this referendum, using taxpayers' money to get a yes vote in this referendum, leaving voters uninformed about what this referendum is really about, and the state taking over parental rights and harming the family.
McCrystal argued that the state was promoting a yes vote in its campaign, using €1.1 million of taxpayers' money in breach of the McKenna judgment. The 1995 landmark case ruled that taxpayers' money can't be used to promote one side in a referendum. The government denied it was promoting a yes vote. But the Taoiseach was adamant this afternoon that the referendum on Saturday won't be affected by today's ruling.
The referendum goes ahead on Saturday. The argument in favour of this referendum remains the same. There is a necessity to include in our Constitution an explicit reference to the rights of children.
The full details of the decision will be given on the 11th of December. Diane Connor, TV3 News at the Supreme Court.
Gardaí and Portlaoise are continuing to...
Thanks, Alan. Tonight we discuss another fine mess this government has caused, this time over the children's referendum. We discuss how much of a mess and can it be cleaned up on time. That's after the break. With opinion polls showing a probably large majority in favour of the government's proposed constitutional amendment on children, the government has managed to put all that in doubt by engaging in conduct which the Supreme Court today found was illegal. Tonight we discuss whether, yet again, this government can wrestle defeat from the jaws of victory, as it did on the proposed amendment on Oireachtas inquiries. With us are Jerry White, Professor of Law at Trinity College Dublin and co-author of the authoritative textbook on the Constitution, McCrystal, the no campaigner who successfully took the case today against the government, Patricia McKenna, a former Green Party MEP who instigated the case that forbade governments from using public monies to favour one side in the constitutional referendum campaign, and Jim Daly, Fine Gael TD for West Cork. Later we'll be joined by John O'Reilly, Director of the Shackleton exhibition at Dún Laoghaire, and we'll talk a bit about that amazing exhibition which is on show at present at the ferry terminal in Dún Laoghaire. If you'd like to comment on the programme, you can text us at 53131 and place the word tonight before you comment. Send us a tweet at #B or email us at tonight@tv3.ie. Mark, tell us how you came to take this case against the state.
When I realised there was problems early on with the government website and the booklet, and you could say that the media campaign starting to get going as well, I started to question the money being spent and considering the sort of environment we're in economically, and also the level of bias. And also I was aware of the McKenna judgment as well, which was meant to protect referendums from this kind of issue happening again. So that's really what triggered it for me, and I started becoming very concerned.
Were you worried that if you lost the case you'd be hit with a huge legal bill?
It's always a worry for people who consider taking cases that will happen. So I will say I took a considered risk for the sake of
Have you loads of money?
Does anybody in this country have loads of money, or who does at this stage? No, I'm not a wealthy man.
Were you given financial backing by anybody?
No. I basically took it on the basis it was a very strong case, and it was of national importance, so it was kind of straightforward.
One of the questions that arise in many people's minds is that having got the Supreme Court to declare that the government, that part of the government's information delivered on the website and by a booklet was illegal, that you may follow this through now and seek an injunction to stop the referendum going ahead on Saturday. Are you going to do that?
Well, I will say, of course, it would cross one's mind about doing things like that, whatever, but there's other, things to look at, what are the legal possibilities at this stage. And of course, as was brought up today, the government is actually in a position to stop the referendum if they want to, with an emergency legislation. So the government, I think, should do something about this issue.
And if it doesn't, will you seek an injunction to stop them going ahead with the referendum?
Well, perhaps tomorrow, we look into this issue, whatever, and just see what's possible and take it from there.
And what you would now, as I've now advised, on whether this is something you should do or not?
I can't really go into that at the moment.
Why not?
We'll just, because there's a lot of information to go through at the moment on that issue, and it's literally very short after the Supreme Court case, which was this morning. So we'll just have to have more thoughts on it.
Jerry White is one of the authorities on the Constitution, often cited in Supreme Court judgments. Jerry, tell us, would an application for an injunction succeed, preventing the government from proceeding with this referendum on Saturday?
I think it would be very difficult to get that type of an injunction. I mean, the courts generally, on the rare enough occasions when they've been asked to address the issue of referenda, they've been very, very reluctant to intervene in a process where the people are expressing their views on amending the Constitution. So if Mr. McCrystal was to bring proceedings, and obviously he'd have to bring them tomorrow, he'd have to have an extremely compelling case. It certainly wouldn't be a slam dunk application to the Supreme Court for an injunction.
Of course, any citizen can apply for an injunction. It doesn't have to be Mark McCrystal. But given what the government found, that the government had acted wrongfully in a manner which was not fair, equal or impartial, it's pretty damning. And
yes, it certainly is embarrassing for the government. That's unquestioned. What's also interesting about the decision, and which would be really interesting if it's a unanimous Supreme Court decision, I'm not sure, it's not clear from the judgment whether it is unanimous, but what I also found interesting about the decision was the affirmation of the original McKenna principles in this very short judgment that was handed down today. And that's interesting because the McKenna principles have been criticised from certain quarters, that it inhibits the role of the government, and that the government should be allowed to spend public monies in referenda campaigns. But there's a passage in this judgment which to me reads as an affirmation of the McKenna principles by the Supreme Court. And as I said a moment ago, if that's a unanimous 5-person court, it's a really strong.
Were you one of the critics of the McKenna judgment?
No, I haven't commented one way or the other on the McKenna principles, really.
Just briefly tell us what the McKenna judgment said.
Yes, well, I think it's welcome the opportunity to try and clarify the McKenna principles, because I think there's a little bit of confusion about it. But the point is fairly straightforward, and it's this, that in relation to referenda campaigns, the government of the day is not allowed to spend public monies on one side or the other of the debate. The government is free to campaign for a particular position. You'd imagine, obviously, if a government...
Not as the government, really.
Well, government ministers are perfectly free.
But as members of their various parties, but not as...
Well, I mean, a government minister can come along on the airwaves and say that she is the minister for X, and she is calling for...
Okay.
Yeah, so the critical thing is the expenditure of public monies. That's the problem here, that public monies, according to the Supreme Court, were spent in a partisan way in this particular campaign, and that's why the Supreme Court granted the declaration today that the government's behaviour was unlawful in that regard.
Yeah, and when was the McKenna judgment? How many years ago was that?
1995.
Yeah, and it wasn't a unanimous judgment of the Supreme Court.
It was a 4-1.
Yeah, but today it seems to have been a unanimous decision to affirm the McKenna judgment.
Well, the document refers to a ruling of the court. Now, don't want to get too technical here, but there's only one particular type of case in which the Supreme Court is obliged to give a one-judgment rule, what we call a one-judgment rule, without disclosing whether there were majorities or minorities. This isn't that type of case. But this is what was handed down today was an immediate response. Obviously there was time pressures on the Supreme Court to get out some decision. Whether ruling of the court means a unanimous ruling of the court or whether it's a 3-2 or a 4-1 majority, we'll just have to wait until the individual judgments are delivered in December.
Jim, another fine mess.
Look, yeah, it's a development. Certainly we could have done without, and when I say we, I mean, the campaign for yes in this referendum to date, of which I might add it's not just the government. There's many, as Patricia alluded to there earlier, there's many of civil society as well. The government doesn't have the sole proprietary rights of this campaign. There's many people out there campaigning for yes.
The government screwed it up.
Well, the mistake that was made today, I mean, clearly the Supreme Court opinion was that it was wrong what the government did to spend money promoting a yes side as part of giving out the information. Now the government did strive just to present the information in a fair way. It sought legal advice on that to see how it was doing. The High Court said, the President of the High Court thought it was okay, but the Supreme Court, which clearly is the Supreme Court of the land, has found out that it's not okay, and that has to be accepted by the government.
Yeah, that ministers were involved in drafting bits of the document that is now being found to have been in part illegal. Is interesting. I wondered, did it get legal vetting after the minister's issue? Do you know?
I would be fairly sure it was, that the final draft was submitted to the AG's office. I would be reasonably confident that it was. I think they were very conscious of the McKenna judgment. It was something that was talked about a lot. I'm not privy to all the conversations, obviously, of the government. I would have been involved more in the party's campaign, but certainly the McKenna judgment was very much to the fore in the preparation of that booklet. And it was submitted for, and somewhere along the way, somebody got it wrong. There's no doubt about that.
The McKenna judgment, Patricia, of course, the McKenna judgment is the Patricia McKenna judgment. Yeah. And you must be encouraged that not alone did the court not overturn that judgment today, but seems to have given it an affirmation that was maybe stronger than was originally given.
Yeah, I think it's very welcome, and I think while it's been said that the government was very conscious of the McKenna judgment and the McKenna principles, they have been, but they have shown, by what they've done, that they've tried to circumvent them at every opportunity. And this isn't the first time the government has produced a booklet in a referendum trying to advocate a particular outcome. They did the same last year in the fiscal treaty referendum. And again, when you have a government producing so-called information with an objective in mind that the government wants something to go through, naturally it's a foregone conclusion that it's going to be very difficult for them to present that information in an impartial way. There will always be a slant on it, and I think now is the time to look at how the government has behaved in referenda, where they have, first of all, they set up the Referendum Commission after the McKenna judgment, and they gave the Referendum Commission the role of giving the public both sides of the argument. But when the public, in their wisdom, voted no in a referendum, then they decided to remove that role from the Referendum Commission, and they have restricted what the Referendum Commission can do in a referendum. And I think now is the time to look at giving the Referendum Commission back its original role, because there are many people out there, regardless of what the issue is they're voting on a referendum, who want to see both sides of the argument, and they want to get it. You can get it from political parties or whatever you like, but if you get it from a body, an independent body, headed up by a judge, there's a better guarantee that that information is going to be accurate, first of all, and it's going to be impartial, and then let the people look at both sides of the argument and make up their own mind. It's all about fairness and equality. You can't tell the people, look, we can't amend the Constitution without your permission, and we're going to allow you to make that decision, but we're not going to give you a free and open environment to make the decision in. We're actually going to use your money to persuade you to go in one direction. It just beggars belief, and I think that what the Supreme Court has decided today is the obvious thing that they would have had to do in the interests of democracy, fairness and equality. And I think now is the time for this government to show that in the future they are not going to go down this road of trying to use the public money to get the result they want.
Do you think the government should abandon the referendum now and postpone it for a month or two?
No, I don't think so. I think, look, there are lessons to be learnt in this, and I think that if, regardless of what the outcome of the referendum is next week, on Saturday, either way, the government have actually, if, for example, it encourages more people to vote no because they're annoyed with what the government has done, it's the government's fault. If they didn't allow the people the right to get both sides of the argument, And even if people come out and they say yes,
do you know
Saturday,
anybody who read these leaflets?
Well, people, well, to be honest now, funny enough, I was talking to some friends of mine who are annoyed at the fact that they haven't had both sides of the argument, and they're saying to me, the Referendum Commission, again, this is the issue, they're confusing the booklet from the government with the information from the Referendum Commission, and again, you have to look at what the government has done. In the referendum on the fiscal treaty last year, the government produced a website, produced a booklet, etc. And what they did was they almost designed it very similar to what the Referendum Commission was doing, confusing the public. And when the public get the information, they think this is going to be balanced and impartial.
But do you think anybody read it?
Oh, so a lot of people do actually look at it. They do read it.
Do you know anyone who read it?
Yes, I do.
Who?
Indeed. Well, friends of mine have read it, you know.
And they told you they'd read this thing?
No, they
How's that of their lives?
Well, I think people are interested, people who are going to go out and vote, Vincent, are interested in, you know, trying to inform themselves before they go out and vote.
Watch debates on television and listen to them on radio and all that. But read that stuff that comes in the letterbox.
Believe me, they do.
There are people who read junk mail, are there?
Well, no. I think when you know that you're going to be going down to the polling station on Saturday with your polling card and you're going to be marking a box, whichever box it may be, you will want to inform yourself that you're making the right decision. And I don't think you can sort of dismiss the public's lack of interest. A lot of people out there are very interested in what they do, very concerned about what they do in relation to amending the Constitution, because don't forget, Vincent, as soon as you put an amendment into the Constitution and you change it, you have to wait for time eternity for a government to come back and say, whoops, we've made a mistake, we want to change it, because the public can't initiate
All right, Mark, you obviously
Constitution.
read it.
I have. And,
why did you do that to yourself?
Why did I torture myself? Because anything the government does in that area should be of interest to citizens before they're put into place. They've got to, as Patricia said, make changes to the Constitution, because then we have to live with it. But I want to say as well that, you know, today's judgment shows what the People Know campaign were saying. You know, that it was misleading, and it has been deceiving voters, and the government has had to admit it has made mistakes in that, but it hasn't made much of an effort to change it.
Yeah, but it doesn't make any difference to the substantive issue of whether to vote yes or no. This is a sideshow. Well, it may damage the credibility of the government in arguing for a yes vote, but it makes no difference to the substantive argument.
If the government can get something as important as a referendum wrong, then what else can you trust the government on?
Nobody said they got it wrong, to be fair. Nobody said they got it wrong, or nobody said it was misleading. I mean, you cannot put words like misleading and wrong into the judgment that came out today. Or neither can you say, to be fair, Patricia, that the judgment...
You can't put the word wrong into the judgment.
Well, misleading is the word. You can't say that's misleading.
Well, they've acted wrongfully. In a manner which was not fair, equal or impartial.
Yeah, but that's spending money. I mean, he's borrowing the no argument. That what Mark was trying to do was borrow the no argument along that this is wrong, that a substantive issue is wrong, and people are mixing up, and there is a danger that this will distract from the real issue here, which is to get the referendum and to get the amendment passed and get people out there to engage in it. Not in that, like to suggest that 1.2 million was spent to persuade the people isn't accurate now, or isn't fair. That's what you said a while ago, Patricia, that the government spent 1.2 million to persuade. The government, just one second, the government has an onus to inform the people as well, and felt that very strongly. And it is difficult in a case like this to bring across something that can be seen completely, totally and utterly as impartial, because there are so many...
That's what we have a referendum commission for. Why wouldn't the government just leave it up to the referendum commission?
Well, I mean, a former chair of the referendum commission,
I'm sorry?
Nicholas Kearns, a former chair of the referendum commission, Nicholas Kearns, the president of the High Court, had no problem with this booklet.
Well,
only a
clearly,
week ago.
the judges of the Supreme Court disagreed with it.
Accepted. But I mean, Nicholas Kearns had no problem with it. It's a matter of interpretation.
It doesn't matter whether he had a problem with it or not. The fact is the Supreme Court didn't.
Yeah, well, I mean...
Or did have a problem with it, rather, huh?
Yeah, no, and I accept that. I've accepted that from the start of the Supreme Court. We all know that.
Mark, I want to go back to the point that this is a screw-up on the part of the government with regard to an information booklet and website that they produced. But it makes no difference to the substantive arguments for and against.
Well, I would say that, you know, that the referendum wasn't really about protecting children at all, and it was really a smokescreen.
All right, maybe. But do you go along with my suggestion that the outcome of this Supreme Court judgment today makes no difference at all to the substantive arguments for and against this referendum, this proposed amendment?
Well, I would say that what didn't come out in the government publications was, you know, there was an agenda to destroy the rights of parents to protect their children, and that didn't come across.
But just stress the point I'm making, that this the finding that the government screwed up with regard to a leaflet and a website that they produced is of no consequence, it is of no bearing on the substantive issues either for or against this proposed amendment?
Well, first of all, there's the legal matter. Like when you're asking people to sign up for a change in their rights or an erosion of rights, it's very, very important that it's done, you know, fairly. As I said,
I agree. Yeah.
And if there's a breakdown in that process, or if people aren't being told the full story, then you know, how can you have a contract under those circumstances? You know, changing the law on the basis that people weren't informed properly.
But any of the arguments that you've heard in favour of this referendum campaign, in your view, would those arguments have to be withdrawn or amended to take account of this judgment? My suggestion to you is no.
A huge amount of money and damage has been done to the process, obviously, and look, how would a person, you know, correct it at this stage? It's very late in the day, and the government was made aware of it many weeks ago that there was problems and didn't make any effort to correct it. So there's no, you know.
You're not addressing my question. My question is, can you think of any of the arguments that have been advanced on the yes side of this campaign that would have to now be withdrawn or amended in the light of this judgment?
Well, one would be that claiming to protecting children. I would have a serious problem with that.
But how does that bear? How is that relevant to this judgment?
Because in this judgment, people weren't given the information to make a decision. You know, they were told this is about protecting children. And it was about you know, destroying the rights of parents.
How does this ruling?
The Irish people had a right to know
that
matter, and they weren't told this by the government. Basically, there was they want to lose their rights over the children. Basically, it was going to be transferred to the government. People were not told that, and that's an important thing. They should have been told. They should have come out in the government publications.
Saying that
the government has an obligation to tell people that, and they failed to do that.
Jerry, do you think that's so?
No, I think what the Supreme Court said today was that the government could not advance certain arguments using public monies.
Yeah, that's
now, the government could advance those arguments if it didn't use public monies. Supreme Court would have had no difficulty with that. So the judgment is not about whether arguments for one side or the other are in themselves right or wrong. It's about this process of using public monies to advance one side of the debate. And then equally, civil society people, they're free to spend whatever money they want, their own monies, arguing for or against the proposal. I think the Supreme Court made it clear that their decision wasn't addressing the substantive issue of the referendum itself.
The Patricia McKenna judgment arose in connection with the divorce referendum, and subsequent to the divorce referendum outcome, a case was taken by Des Hanafin, a former senator and father of Mary Hanafin, a former government minister, arguing that the result of that divorce referendum was invalid because of the wrongful information that had been supplied. And the Supreme Court found that this wasn't so because it found that the wrongful information had no effect at all, that the use of public funds in the course of that referendum campaign was entirely wasted, and the government celebrated this because it meant the defeat of the Des Hanafin case.
Yeah, I slightly finesse what you've said. I mean, under the Referendum Act 1994, if you want to challenge the outcome of a referendum, one of the ways in which you could challenge it to establish that there was an unlawful interference with the conduct of the referendum process that materially affected the outcome. There's two elements in that test. Now, clearly, the fact that the government has spent money on one side of the referendum campaign, that is an unlawful interference with the conduct of the referendum process, and that's what the Supreme Court has ruled today. But the second limb of the test is whether or not spending that public money on that publicity campaign will affect the way people decide to vote. And what happened in the Hanafin case was that the Supreme Court, well, first of all, the onus of the burden of proof was on Des Hanafin to establish that the publicity campaign did have an impact on how people voted, and he wasn't able to establish that.
I remember that case that the government had experts on public opinion and advertising who testified that the advertising campaign had no effect at all. And it was quite fantastic, wasn't it?
Well, yeah.
And the Supreme Court bought this. No effect. They spent, I don't know, I've forgotten how much money they spent on it. And do you remember that, Jim?
500,000.
Barely, only barely. That's all about it.
But you see, the thing is that I think after the referendum is over, it's very difficult to decide, you know, what way people would have voted anyway. Like if you take this referendum, you know, after it's over, people can say, well, look, the fact that the government was found to be acting unconstitutionally has persuaded people to vote no, that we're going to vote yes. Or, you know, people may have voted no because, or voted yes because they're worried about the fact of the Supreme Court judgment and not enough people would do it. You can't decide. But I think what Jim is saying here is very, I suppose, misleading in relation to the government's motivation behind using the money for a so-called information campaign, because it doesn't make any sense if you've got a referendum commission. And what the government did was they said, right, we're giving the referendum commission, you know, 1 million something euro to spend, and on the same day they said we're allocating ourselves to something similar. And by the way, we've all our research and work done, we've a website up and running, ready to put on, and the referendum commission are starting off from scratch within the same time limit that the government have already got all the work done. I mean, I think that the government, this government and successive governments, have been reluctant to allow the referendum commission a really good opportunity to do its job properly, because if you look back at the history of the referendum commission, they've been given 2 or 3 issues to give the public information on the same day. They've been given very little time. And I think, and this judgment is extremely important, because the government are now deciding they're going to get rid of the Senate, and they're not putting this to as part of this Constitutional Commission to discuss. They've decided that we're going to have a referendum on abolition of the Senate. And if the judgment today hadn't happened, the government could have very easily used a so-called public information campaign saying, no, we need to get rid of the Senate because we need to save money, you know, it doesn't do its job properly, etc., etc., without giving people the opportunity to hear both sides of the argument.
I want to go to a break in a moment, but before we do, we want to go just 2 issues. Jim, is there anything this government can be trusted not to screw up?
You know, talking about this government and what this government did, I think what this government was trying to do genuinely was present a partial explanation of what was at issue. I mean, one of the criticisms one of the criticisms we got from the previous referendum on judges' pay and on the Oireachtas inquiries was that we didn't make enough effort to inform people of the issues. And we, as members of the parties that make up the government, were on the doorsteps, and the typical reaction we were getting day in, day out was, we don't know anything about it. We don't know anything about it.
Give the money to the referendum commission and give them
well, the referendum commission were doing their job, but the government, I think, believed in it. No, let me finish, I didn't interrupt you. The government believed genuinely that it could present a partial explanation of what was in this referendum. Now, we've been told today by the Supreme Court that it wasn't impartial, but we believe we could. And the government, to be fair, did everything in their power to try and make it. It wasn't like that they were trying to circumvent the McKenna judgment. Well, according to the Supreme Court, they spent monies. Yes,
they screwed it up.
Yes,
now, my question was, can this government be trusted not to screw everything up?
I think it can, Vincent.
What's the evidence for that?
Well, the government have got lots of things right. This is just, I mean, if I was here a week ago, we'd have been talking about the High Court judgment that vindicated the actions of the government. And in this particular case, we would have been talking about the High Court judgment that vindicated and supported and said the government got it right. That was a week ago.
Yeah, and we would have been wrong had we said the government got it right, wouldn't we?
No, not just as a matter of fact.
Yeah, well, wouldn't we? We would have been wrong. So can you think of, just quickly off the top of your head, what haven't they screwed up?
The government is doing umpteen things day in, day out in actions and passing laws.
I think it's interesting that you can't think of any specific thing off the top of your head. Mark.
I'll give you a list after the break.
Tell us a bit about your background. Have you been involved in campaigns before?
I've always taken interest in national issues, and you know, particularly when it's going to affect the people of the nation. So I've been involved in, let's say, you know, previous referendums.
What referenda?
I was involved in Lisbon, for example, and I would have taken an interest anyway. Anything which changes the laws and affects the rights of the Irish people is of great importance to me. So,
were you involved in the divorce referendum?
That was I wasn't living. I was living in the north, I think, at the time. So I wasn't around at that stage. I was really a bit younger then, of course. So I wasn't quite up to speed in those things back then. So
and briefly, what has alarmed you about the proposed amendment to do with children that has encouraged you to campaign on the no side and to risk taking a case?
I'm concerned basically for, you know, in the Constitution, the government has an obligation to protect families. and the government's been failing in that area, and then to try and move in then and try to, well, as I see it, extract the child outside the family and make it an entity subject to the government.
How is this? How would they be extracting the child from the family?
Well, the child is obviously part of the family, but it's already protected by the Constitution. So
and the existing Constitution permits the removal of a child from a family in certain exceptional circumstances.
The government has had all the power it needs over many, many years to take care of children, and this referendum was unnecessary. The government doesn't need more power to protect children. So I was very, very, it concerns me what was the power for.
Do you think that the provision in the proposed referendum that permits the adoption of children who have been abandoned by their parents or abused by their parents or whatever, married parents, and who are already gone from the family, do you think that the provision that allows those children now to be adopted is a welcome one?
Well, those cases, as far as I know, are few and far between.
But even that's so, is it welcome?
I don't think we really needed a referendum for that. It was possible to work with that. As far as I know, we didn't need a referendum to fix those things.
Well, a lot of constitutional lawyers think differently. But do you think it's a welcome development?
A welcome development
that if this constitutional amendment passes, that children who are already removed from parents who are married and are in foster care can now be legally adopted if this referendum passes. Do you think that's a welcome development?
Well, I think that to do so much radical changes to the Constitution and the rights of all children and all parents in this country, just for that matter, it could have been done far differently.
All right, we've got to take a break now, and after the break we'll talk a bit about the Shackleton exhibition in Dún Laoghaire and also preview tomorrow morning's newspapers. Join us then. Welcome back. Because I gave Mark McCrystal a little time before the break to talk about arguments for the no side, I want to go briefly to Jim Daly to talk about arguments for the yes side. Jim, very briefly.
Yeah, look, the Constitution is a reflection of society at any time of how they value anything, and this is a chance 20 years on. I think now we have to realise that children should be not just seen but also heard. Typically they were only just seen and not heard. That's what I grew up with. This is our opportunity to put children at the heart of it, to ensure their welfare and their rights at the central stage, and give them the opportunity that you mentioned about the children who are in foster care, who want to have loving families adopt them on a full-time basis and allow them to become part of that family rather than being in and out of foster care on an ongoing basis, which has been very, very detrimental to their well-being over the years.
All right, thank you very much. Go to some of your texts and tweets. Martha Tobin says that he's decided to vote no, or she has decided to vote no, as need to have proper debate or to children to get it right. Yvonne Whelan says, please vote yes for abused children, not about politics. Jane Hardy says, demand a new vote by ensuring a big no vote this Saturday. Send Gilmore and Co a message. Damien Hanlon says Francis Fitzgerald and the government are treating the Irish Constitution as if it were the news of the world. Mara Ben says how arrogant is Shatter, and now Francis Fitzgerald is not giving us an apology. I think Francis Fitzgerald did give an apology this evening on television. Jennifer Banks says, I hoped the referendum would be rights-based, not giving the state parental powers. Power wording needs to be rewritten, and other tweets and texts along those lines. All right, we have John O'Reilly, director of the Shackleton exhibition in Dún Laoghaire.